today's topic is management matters. Management matters, management matters, management matters. And the reason today's topic is that is over the past 2 years, COVID and all the craziness and inflation and people being stuck in their house has really chewed up a lot of managers. And people don't realize that, and people don't realize how difficult it is to get a good manager. It is really, really difficult, and good managers are worth their weight in gold. So well, first of all, let me get to my announcement so someone doesn't sue me. Please don't sue me. So number one, these webinars are provided for general informational discussion purposes only. These webinars do not and cannot form an attorney-client relationship. The information exchange does not constitute legal advice. To obtain legal advice, you have to go out and contact your own attorney directly and enter into a written retainer agreement. No information contained during these sessions or seminars or chat room will be maintained as confidential. We will tell everyone about you, everything you tell us. So don't tell us any secrets, at least not during this webinar. You can tell us secrets later on, but not during the webinar. So save tens of thousands of dollars on lawyers, engineers, and accountants. That's kind of the first bullet point there. How do you do that? And people who know me have heard me say this before. Every dollar that you chisel down on management services, you spend 3 on lawyers, engineers, and accountants. It's just, you should not skimp on management. Management, like I said, I'll say it again, is worth its weight in gold. What we see time and time again, we go into interview at a place and we see the management companies that are bidding there, and they are bidding down, down, down to the basement. And honestly, we would rather not have those sites, right? Because what's happening there is the association is going to get the lowest priced manager. That the manager is going to get chewed up. Bad things are going to happen. The lawyers are going to be called all the time. The auditors are going to be called all the time, and the engineers are going to be called all the time after the bad stuff happens. So after the common property is not maintained properly, after various things are not done properly, like putting carriers on notice on a timely basis, et cetera, after the audit materials are not provided to the auditor in a timely fashion. And it's just more and more problems. You have auditors recreating books and records. You have the lawyers stuck in a position where we can't effectively do collections because we can't get a straight account history. And our paralegals and attorneys here have to spend hours trying to recreate account histories. So keep in mind when you're out to bid for management and you're looking at management, or even looking to change management, especially, think twice. If you have good management, do everything in your power to keep that management. If you're going out to bid for management because there's a problem or a concern, keep in mind that often, if not always, the low price bidder is not the answer, okay? So please, when you sit down with your management contenders, walk through the process with them, find out what they do. Don't just go to the lowest cost vendor. It will get you in trouble. So management company, association employees, and board members. A lot of this stuff is very rudimentary for people who have been in the industry for a long time, but a lot of people it's not. So many associations, in fact, the majority that we work with are managed by management companies, right? They're management companies that work for the board. And then they have a management team that may be on site. So you have a property manager on site, but people forget about the back office. So typically a good management company will have a robust back office with good financial record keeping, good financial reporting, good violation tracking, good work order tracking, all those types of things. So not only do you have to look at the person who is sitting on your site perhaps, or who is shaking hands with you when she or he comes to the board meeting, you have to have some grasp of what's happening on the back end of the management company. And many people overlook that. You might want to get a look at what the financial statements they are in terms of what is prepared every month, what the board packets look like for that management company, and so forth. Now, association employees, many, especially active adult communities we work with, the larger ones, actually hire their own direct employees for management, right? Which is fine, which is fine. So long as those people are trained and properly managed, right? And whoever is the general manager, he or she, understands how to manage an office and understands how to deal with personnel issues in particular, right? Because the biggest stumbling block that I see with association employee model, rather than the management company model, is the stumbling block of mishandled personnel matters. Um, let's see, the next one, which is pretty rare. We do have some associations that have this model where the board members themselves, it's usually smaller associations, the board members themselves actually run the day-to-day affairs of the association. And I cannot think of a bigger nightmare, honestly, and that may sound scary, but who wants to buy into a nice house and then get themselves a job that they're not being paid for? So it's okay. I mean, it does work if you have wonderful, wonderful board members that are willing to dedicate the time, energy, and effort to do that. That's fine. It's a fine model, but it's a very challenging model because often it ties the board members to actually having a job. Somebody has to be there. Somebody has to make sure that the things get done, and you're in tough shape. One thing that's happening today, and people may not realize this when I say how valuable managers are today, most management companies do not have a bench, And what that generally means is good managers are scarce. So if you don't like the manager who's working for you today and you say, I'm going to kick her to the curb, there's nobody else there. There's nobody else at company A. There's nobody else at company B. There's nobody else at company C. So think twice before you get frustrated and you impulsively kick somebody to the curb, because there are no people sitting on the bench right now that I know of, or I should say very few. 10 years ago, resumes were circulating. People were looking for work. People were looking for positions. People were looking to move up and move sideways and move around. But that's not the case right now. So be careful if you are frustrated with your current manager. Try your best to work through it in an intelligent way. Now, the manager themselves, we've talked about this before on First Friday with Fran. The manager is not a whipping post. And if you're on the board, you must not let that happen. Must not. Not only will the manager leave and you will leave, a good manager will be gone, there's a very good chance that the association and or the management company will be sued for allowing that to happen. People forget that managers are employees, and oftentimes under the law, they can be construed as co-employees of the association and the management company, even though technically on the books, they're employees of the management company. So you have to be very, very careful about that. One of the questions that's often asked, and a lot of management companies are uncomfortable with this, and I understand it, is can we meet the manager before we hire the management company? That's really tough. Sometimes yes, but sometimes it can be very, very difficult because, as I said, that person is typically not sitting on a bench somewhere. Usually she is working somewhere else, right, before she has to come in for an interview, because most management companies can't afford the overhead of just having a manager or two or three or four sitting idle without running a site, right? So I think it's worthwhile asking, because in this world, it's management services are often so personal. So if I was sitting in board member shoes, I would like to talk to the potential property manager if I could. It's just not always possible. The other thing that you want to be careful of, is the good ones don't do this, but sometimes the lesser ones do. They trot around the same person. This is going to be your property manager, and that person is a rock and roll star, right? And then you sign with that management company, and Schlubbo the clown shows up, and you're like, wait a second, I had a rock star at the interview, and now I got Schlubbo the clown. What happened? What happened to the rock star? So make sure that you understand who's doing what, who's going to be where. Typically, you cannot put an individual in a management agreement. You can't require that a manager stay there. I've seen a few associations work special deals, but it's very rare because the management company generally is not able to tie themselves to an individual person. Sited versus portfolio managers. Many people don't realize the difference between a sited and a portfolio manager. And sometimes it's a combination of both. So a sited manager is what it says it is. The manager actually sits on the site, right? She or he is the person who sits in the office, deals directly with homeowners, deals directly with board members, et cetera, et cetera. And that is the only association she manages or he manages. So that's typically the sited. Some sited managers will have a smaller association, say across the street or in the neighborhood that they're also managing. And that's fine as long as the manager has the bandwidth to do that and as long as that's disclosed to the association's board. A different type of model for a property manager is the portfolio manager. And a portfolio manager manages more than one association at any given time. A very, very, very challenging job, a very challenging job. And what has happened in the community association industries to managers that are portfolio managers is as the margins have gotten smaller and smaller and smaller in the management industry, portfolio managers have been asked to handle more and more accounts, right? So a new manager comes on to a property management company and they say, hey, you know, it's going to be great. We're going to give you 4 sites. You're going to make X dollars. Everything's going to be wonderful. And 2 weeks later, she or he is asked to do another site. Oh, and I'll give you a bump of a couple bucks. Then you got 5 sites. And then, you know, for another couple bucks, you get 6 sites. And another couple bucks, you get 7 sites. I was with a manager earlier this week who had 13 sites. 13 sites, right? I don't know of anybody who has the bandwidth to handle that. So you have to be cautious if you're going to be working with a portfolio manager. Understand what is her bandwidth or what is his bandwidth, what she or he has on their plate, and what are you paying for? Because I have a number of associations where they have a manager perhaps under contract for 1 day a week or 20 hours a week, and they want her to work 150 hours a week, right, for that 20-hour contract. And this is the sad part. The good managers try to work 120 hours a week to satisfy the people they're working for, even though they only have a 20-hour contract, right? And then the manager gets fried, right, and leaves the management company and or leaves, God forbid, the industry, notwithstanding the fact that they were good managers, right? So they just get ground up. So when you're looking at the portfolio managers, make sure that you're going out to bid and you're paying for what you're getting. So if you're paying for 20 hours and you know this manager is actually working 40 hours or 50 hours for your association, please just go back to the management company and say, listen, we realized that we need our community and our members need much more services than we originally anticipated. We'd like to increase the contract to 40 hours or what have you. Up in Jersey City, I had a manager who was working on Sundays on a part-time contract, and he was just getting fried and chewed up. And luckily, the board was smart enough to realize they're misjudging the management needs, and they did bring him on as a full-time manager, and he dropped the other sites that were in his portfolio, which worked out really well for both the association, the management company, and the manager himself. So that's sited versus portfolio managers. Now, manager education, and people who know me, I see Larry on the call. I have a long time passion for manager education. I speak a lot. I see people like Liz out here. I speak with a lot of people who are on this call, actually, in terms of seminars, et cetera. Manager education is crucial. And our manager population, I would say across the industry, I haven't done a survey, but I would say our manager population across New Jersey is getting older on average. Okay, older on average, and many managers are aging out of the industry, with people leaving the industry, not just because people are driving them nuts, but because they're getting older and retiring. So one thing I think that boards should work hard on is giving your manager and encouraging your manager to get educated, whether it's through CAI or IRM or the Urban Land Institute. There are numerous organizations that provide for management training and certification, but getting educated, providing the time. I don't know how many boards I've worked with where the manager has said, hey, listen, I'd like to do a blah, blah, blah seminar. And the board's like, no, wait a second, you don't have time. I got your time, my time. I'm paying you for that time. Well, education is valuable time, and I believe that education pays back the association over and over. There's that old cliche: if you think education is expensive, imagine the cost of ignorance. So that's for all the teachers out there, high teachers and retired teachers. So ignorance is very expensive. So I'm a big proponent of getting the managers trained, giving them time, giving them money to sign up for courses, paying for that. I think it's a fair request. And also, if they do get certified, if they do reach milestones in their career, giving them a compensation bump, whether that's in the form of a salary bump or a bonus for hitting that milestone in their career. I think they're all helpful, and it's really helpful to encourage people to do that. Financial management and a la carte management. So many associations feel they don't have the need, or they're not big enough, or they're not sophisticated enough that they really need full-time management. They don't need a manager. They don't need a manager on site. They really don't need a full, either a portfolio manager or a sited manager. Many of the management companies, especially the larger ones these days, are willing to at least put a proposal together and say, hey, even if you have your own employee, or even if you don't feel the need to have employees, we will provide back office services, whether it be financial, whether it work, ticket item tracking, et cetera, on a limited or a modified or a hybrid type management agreement service. So that allows the association to try the professional management route without jumping in with both feet and spending all the money. So it can be very, very helpful. I've seen it be very successful. I've also seen it fail, which is fine. There's nothing wrong with trying things. And then if it doesn't work out, that's fine. Next question is management company related entities. So many management companies in the industry, whether you know it or not, are owners or partial owners of other service providers in the industry, whether it's pool companies, landscaping companies, maintenance companies, porter companies, et cetera, concierge companies, et cetera. That is not illegal. It's not wrong, but it must be disclosed, right? So anybody you're working with through a management company, if there is a related entity, they should be disclosing that to the board. So the relationship should be disclosed. So for example, if the association is hiring a swimming pool company that is owned by the management company, that should be disclosed, and the board should be aware of it. The board can ask questions about that. It's a double-edged sword sometimes. So people say, oh, isn't the management company getting over on us? Well, not necessarily, because oftentimes if the owned or controlled vendor screws things up, that may come back to bite the management company on the hiney too. So it really depends. It could go really, really well, or it could go not so well. So the most important thing is that the board is fully informed. Most sophisticated management companies today, if they do have an ownership interest in a vendor, they actually disclose it in the management agreement itself, right? So you want to read your management agreement. If there is a schedule attached to your management agreement, check that out and make sure that when you're going out to bid, you know who are the related entities and who are not related entities. There are some boards I work with who say, no, Fran, we're never going to deal with related entities at all. We're just not comfortable with it. We think it complicates the bidding process. Other ones say, hey, I think it's fantastic. I think they're going to work with us. I think they're going to bring people to the table that are good people. So it's really a call for the board, but knowledge is power there. Let's see. Indemnification, defense, and hold harmless provisions. There are many board members who feel that the management company should not be indemnified, defended, and held harmless by the association. And that just makes no sense. And the reason for that is management companies and managers act in an agency capacity on behalf of the association. They aren't acting on their own initiative, right? So long as a property manager or management company is acting within the scope of their duties under the management agreement, they should be indemnified, defended, and held harmless. So indemnified basically means, hey, if somebody goes after the manager and based on what she or he has done, pursuant to their agency relationship with the association, and gets a judgment or penalties against the manager, the association, or in most cases, the association's insurance company, will indemnify the manager, which means basically pay for the issue, right? Reimburse the issue. Defend means you'll pay the manager's attorney fees or the management company's attorney fees. So typically, again, it's the association's insurance company who will come in and defend the manager, defend the management company on the claim, so long as the claim is within the scope of the manager's agency relationship, and the manager has not done things purposely, usually purposely, or sometimes grossly negligent. It really depends. Really depends. The last is hold harmless. What does it mean to hold harmless? It means that if the association were to indemnify and defend the manager, the association won't then go back and sue the manager to recoup what they just paid out to defend and indemnify the manager, right? That makes sense, right? Because otherwise you'd have all these gotcha lawsuits where the association would say, listen, I indemnified and defended you. Now I'm going to sue you. How you like me now? Which we can't, makes no sense, right? It's just taking the issue off the table. So the one thing I will say is when you're looking at management agreements, most of the more sophisticated management agreements today have the agreements to indemnify, defend, and hold harmless pretty narrowly tailored to be within the scope of the agency relationship, right? However, there are still management agreements floating out there that basically provide indemnification, defense, and hold harmless for everything. You don't want that, right? You want to narrowly tailor that to make sure it's appropriate to relationship. Like, for example, years ago, I said to a person in a management company, I said, listen, man, I've read your indemnification language, and you can purposely run somebody over in the parking lot, and you would still be indemnified under this language. And he's like, come on, Fran, come on. I said, no, we gotta adjust this language, which he ultimately agreed to. Successor planning. Successor planning. What is successor planning? Those of you from the business world, you know this. If your manager is getting to a point in his or her career that you don't think she's going to be around much longer, I don't mean dying, but I mean moving on in her career, moving to a vice president level, moving out of the industry and retiring, you have to start thinking about who's the successor going to be. If you have a situation where you have an assistant manager or a buildings and grounds manager, I have in some cases, you should be thinking about cultivating them and bringing them along and exposing them to the operations of the association so that when the day comes when he or she, the general manager, leaves, someone can step almost seamlessly into his or her shoes, right? That makes sense. Otherwise, what's going to happen is you're going to have a huge gaping gap in terms of property management. Because like I said before, there's no bench. There aren't people just hanging out. And you need to communicate with whoever you're cultivating as a successor that, in fact, that's why you are cultivating them. You don't want to make a promise. I promise you 5 years from now, you will be the property manager. You can't do that. Then you get sued on a contract claim. But you can say to them, listen, we're trying to work with you. We're trying to bring you along so that they know that they have a future with the organization, right? You want to build them, to educate them, and to bring them along. Because again, there's no bench out there. Management company turnover. So we're getting close to 4:30, but management company turnover. Give me 1 second. This is always a difficult one, so I had to have a little sip there. So management company turnover is always annoying, right? Because it's disruptive. You lose institutional knowledge generally, and it can be very difficult if you're leaving a management company that, in my view, is not kosher, right? And when I say not kosher, what I mean is, oh, Fran, we lost the files. We deleted all the files. We can't find the files. We can't get the files. Nonsense, nonsense, nonsense. So two things, if you are turning over in the management company world, make sure you do everything possible to get the files. And that usually means involving us. Like I said, with your normal professional management companies, it's usually seamless. You say the good management company says, hey man, things didn't work out. That's fine. Hopefully someday they'll bring us back. But here are the files and everything's cool. But we do have those instances where it's not so cool. So make sure you get the files. Make sure you work with counsel to make sure all the files are secured. That's number one. Make sure you do not hire a new management company without properly terminating the prior management company. This happens to us as lawyers all the time. We get a phone call and they go, hey, Fran, we're sending over the contract for blah, blah, blah management company. We intend to sign it tomorrow morning. You go, really? I thought ABC Management was your management company. And they go, yeah, well, they're gone. They're out. They're fired. You go, well, did we send them a termination notice? No. Why would we do that? I told the manager she's fired. Okay. What did she do wrong? I don't like her. I told you I don't like her. Okay. That's not helping me. Right. And then what they do, and I've seen this happen several times, is sometimes they don't even send us the new management agreement before they sign it. So they wind up with two management companies at the same time. You have two management companies retained at the same time. And the outgoing management company says, you didn't provide me proper notification in terms of termination. So I got 90 days before I'm gone. So you can do one of two things. You can either let me manage for 90 more days, or you can pay me 90 days worth of management fees, and a new management company can start whenever they want. So you have to be very cautious in the management company turnover process. Let's see. Mike, you want to jump in on some questions there?
Yeah, absolutely. Hi, everybody. Mike Palulak here. So the first question is from Jeff Schiffman. Can a board member who will not have knowledge of the votes to be taken give a proxy to another board member? I believe the answer to that is generally no. And the reason why is because the board members need to have an opportunity to participate in the discussions at the meeting, whether they're in person, whether they're on a conference call, where they can hear and partake in the discussions. Play it out for a second. If somebody were to give somebody a proxy to say, hey, I want to vote yes for this contract, a motion is then made at the meeting to vote on the contract, and a bunch of discussions then ensue amongst the board, and a bunch of new facts that the absent board member didn't know came up. That person very well may have changed their mind and not voted in favor of that particular contract. So it's really important that the board member is present in person or available virtually on Zoom or on a conference call so that they can participate.
Okay, your thoughts on switching to self-manage for a large community association? So I guess what that's saying is going from professional management or a management company, if you will, to self-managed employee model management. I think it's doable. I think now would be a really, really, really bad time to try that. The reason, like I said, is nobody's sitting around waiting to be hired right now. So you would have to pay a significant premium to recruit the talent and build a team to walk into a professionally managed association where you need a full team. I don't see that as a practical option at the moment, but it may be more practical in a different economic environment and in a different personnel environment. Right now, though, I don't see it as a practical option.
Right. The next question is from Danita. Hello, Danita. She writes, Senate Bill S2861 eliminates age restrictions on deeds and governing documents, and impacts, however, only deeds recorded on or after January 1st, 2021. So how does this impact communities with prior year governing documents, and is it in conflict with the Housing for Older Persons Act? Will amendments still be required to make changes? So this bill was passed and became law in, I believe it was November of this past year. And what it states, amongst other things, is that community associations have an obligation. They have a 90-day period in which they are required to review their governing documents to ensure that there is no discriminatory language. Now, Danita brings up a good point. How about 55 and older communities? That is, by definition, discriminating by age. So there is a federal law, the Housing for Older Persons Act, which permits community associations to discriminate by age as long as it meets certain criteria, such as more than 80% of the people residing there or over the age of 55, and a couple other small requirements. This law does not trump that. The Federal Housing for Older Persons Act still supersedes, right, this new law. We actually went through that whole process of making sure that that is the case, and yes, that is the case. So you're not going to lose your age restriction. However, especially 55 and older communities should review the governing documents. There are some communities that have language, for example, that says in order to own a unit in the community, you must be 55 and older. That's out there, especially on some of the older communities that were built in the 80s and 90s. they have that language, so that needs to be taken out. And there's an affirmative obligation here to review and to amend to remove those provisions.
Okay. How many properties should one property manager be overseeing? So that has tremendous variables right there. So it depends on the property manager. So there are some really awesome property managers who can do lots of associations. I still don't think it's a wonderful thing to do, but it really depends on the property manager and the association. So people will say, oh, well, it depends just on the size of the association, not necessarily either. So the manager that I mentioned before, who said she had, I forget, 10, 12, 13 associations, whatever it was, she said, oh, but lots of them are small, right? But the problem even is if they're relatively small associations, typically you have a board meeting every month at least. You still have a board meeting every month at least. You still have a board packet every month at least. You still have a financial statement every month at least. So even if it's a smaller association, the manager still may be getting tortured in terms of having to produce product for that association every month. So I guess the real answer to Ann's question is you have to sit down with your property manager and your property management team and say, where are you? What is your bandwidth? I hate to say this, but should we be paying you more to do less, right? In terms of less sites, not less sites for you, but should we be paying you more so that even though right now you have 6 accounts, maybe we'll get you down to 4 accounts, but we'll be willing to pay you more. Is that an option? Many associations cringe when I say that, but the alternative is boards calling me and saying, the manager's not getting anything done. The manager's not getting anything done. The manager's not getting anything done. I'm like, no, the manager's killing herself, right? So she's trying her best. She's losing her mind, but she's not able to deliver because she's overcommitted. And that's a balance. There are some boards who say, that's not my job to have that conversation. That's the management company's job. Let them figure it out. No, this is a relationship, right? This is a relationship among the board, the association, all the professionals to try to get the right thing done. So you can't just wash your hands. I've given you this example before. I went into an association where there was a well-known management company in there that was doing a good job at about $125,000 a year in management fees. They decided to fire that management company. I have no idea why, but I went to a bid meeting and the bidder bid $75,000, going from $125,000 to $75,000. And after the bidder left, I said, people, you are out of your mind if you think that management company is going to be able to do the same job for $75,000. And the board said, that's their problem. And I said, no, it's going to be your problem. It's going to be your problem in 2 months when these new people come in here and the chickens have come home to roost there. If you drive by that community now, it has much less curb appeal, among other things, than it did 2 or 3 years ago. So it's a conversation. I know that's not a great answer, Ann, but it's a conversation. Mike?
Yep, Colleen writes, when a resident complains about an employee, should the board listen to the resident and attempt to have the employee removed? So I think if the association has direct employees working for it, the board just has to remember that you are an employer. So you need to treat this like a regular business. And when somebody complains about an employee, what do? We note the employee's file. It may necessitate sitting down and having a discussion with the employee. We have to speak with our office or the association's counsel to go through the employee handbook, find out if the conduct results in certain measures to be taken against the employee. So it depends on the circumstances, but there should be a procedure in place. I don't think we jump right to having the employee removed. I think we take it step by step by noting the file, sitting down, talking to the employee, reviewing the employee handbook, and then determining what action to take.
Yeah, thanks, Mike. I just wanted to add to that is I like to look at that one as the first step should be pull out the org chart. Pull out the org chart. Because often what happens is a board member gets caught in the parking lot one night when she or he is going to the clubhouse and they say, hey, you know what? This employee's the worst. I can't believe it. He was doing snow removal and he knocked my mailbox off. You got to fire him. He's a dirtbag. No, that's not the answer. Um, Board members should not be running the association, so they should pull out the org chart. And if the org chart says board, like most org charts, board, general manager, blah blah blah, on and on down the staff of the association, those issues, if they're brought to the attention of a board member, should be referred to the person who's to handle that in the org chart, which would typically be the general manager or the property manager. The board members should not be handling those things themselves. And if it is turned over to the property manager should do the proper thing, as Mike said, from an HR perspective, document the issue, document the complaint, meet with the employee, meet with the accuser, meet with third parties that may have to be interviewed, make the record, right? Because at the end of the day, everyone knows this, who's ever been an employer or an employee. If you have not made the record, especially if the person is a member of our protected class, and you wake up one morning, you say, that's the last straw, I'm firing him. And you fire him and he goes, wait a second, you got no right to fire me. Yes, I do. You've been a jerk for 5 years and we've just been putting up with all this nonsense. And he says, well, wait a second, I'm a member of a protected class and I think you're firing me because I'm a member of a protected class. And you go, it has nothing to do with that. There's nothing to do with that. In fact, you've been nasty and mean for 5 years. And he goes, okay, let me see my personnel file. Nothing, right? And then I get the phone call and I say, well, can you show me his annual reviews? And they go, annual what? So the fact of the matter is, if you're going to have an employee issue, it is true, as Mike said, it has to be handled as it would be a normal HR issue. I'll try to start this one, Mike, and then you can jump in if you want. How should a board evaluate the annual performance as well as the renewal of the management contract? Do you have a guide, or where can we find one? So that's a good question, John. So where that starts, John, I think, is the management agreement itself, the org chart and the job description. And I don't know how big your staff would be there, but so where we have places with big staffs, the people have job descriptions. And so you just match the review, the evaluation to the job descriptions. These are the deliverables. This is what we expected of you. This is what you delivered. This is what we expected of Bob. This is what he delivered. This is what's expected of Kathy. This is what she delivered. Or this is what she didn't deliver, or this is what Bob failed to deliver, or this is what the company failed to deliver. So I think it starts with preparing the contract, or before you sign the contract, negotiating the contract, putting in there what you want. There are two schools of thought on this. There are some associations who want to put granular detail in the management agreement. You will show up Monday through Friday between the hours of 8:45 and 9 a.m., right, as the general manager. You will check in with the board president every day via email and via Zoom, blah, 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 very granular. Then the alternate of that is general manager's job is to act as an executive officer of this organization. Do what it takes, hire the people, make it happen within our budget, right? I'm not here. I'm not going to stand over your shoulder. I'm not going to look after you. I'm not going to granularly manage you. It's really a decision of what the board wants to do. I'm more of a fan of allowing experienced, real property managers to do their job, right? Rather than the board having to babysit or look over the shoulder of the person every day. But that's a very good question, John. It really depends on how the board wants to address it. Go ahead, Mike.
The next question says, for self-managed associations of a few units, an owner can serve as management company and a board member. What if they know that the group is making decisions that are not in line with code, city regulations, laws, etc.? What if only the minority, only a few, vote to follow the law and the codes? So it sounds like there's a couple potential issues here. The first being the board member serving as the property manager as well. That just opens up the possibility to somebody alleging self-dealing and breach of fiduciary obligations. Not that that's necessarily happening, but there's a suggestion of impropriety, I think, that comes about whenever you have a situation where somebody's playing the dual roles. One, the fiduciary that's making decisions in the best interest of the community, as opposed to themselves. And then as the managing agent who it sounds like, is getting paid to manage the company and manage the association. I think that has potential issues, and if nothing else, this must be disclosed to all of the members at regularly at open board meetings, so that people are aware of the dual roles that are being played there. If you have the group making decisions that are not in line with the current laws and regulations and city codes and whatnot, what do? Well, the minority would certainly, at a minimum, you would note it in the board meeting minutes, how you're voting, why you're voting, right, at the open board meetings. If necessary, take a stance and actually notify the township that the association is doing something inappropriate. Fran, I don't know if you have any more comments on that.
I mean, I think that's the way to go. I think disclosure is the issue, telling other members, going to governmental bodies if you have to. That is a tough position. And honestly, it's a tough position for us as lawyers sometimes, because often we're on the phone and we say, you must do X, Y, and Z. And they go, hey, thanks so much. And they hang up from us. And a month later, we know they did whatever they wanted. So it can be challenging. Shalish, what is the minimum training required for a property manager? So this has been a hot potato over the past decade and a half. So New Jersey was pushing for a long time for manager licensing, which would require a minimum of manager training, and then a license application test and a certification. That did not pass. I don't know if any of you remember this, but it died on Governor Christie's desk. It actually made it through the legislature, but it died on Governor Christie's desk. So at the moment, there are no licensing requirements. There's no requirement through the state, et cetera, for minimum manager training. There are, I believe, someone, maybe Larry could check me on this. I believe there are some pending bills right now regarding minimum manager training. I don't know that it's a certification bill. CAI National, I think, has kind of changed their position over the years on this. For a while, they were very much in favor of manager certification. Recently, I've heard that has backed off somewhat, and they're not so much in favor of manager certification. I think some of that also depends on the economy and the jobs market. So think of this: if all managers must go through a training course and must be certified to be managers, and you're in a jobs market where there are no people who want to work, how are you going to get services if they're required to go through a training program and a certification test before you get them to work? So as far as I know, there in New Jersey, there's not a minimum certification required. The other thing to keep in mind, and this is pretty common in our industry still, many property managers who are excellent do not have college degrees, right? Do not have college degrees. They've learned through the school of hard knocks, right? They've come up, they've worked through the office, they've learned working through a machine, they've learned working with people, dealing with people, just making things happen. And so some of the best managers out there don't have college degrees or business degrees or MBAs or whatever you think they might have. I would not throw out the baby with the bathwater there. It's not all education. Oftentimes it is life experience as well. So be careful with that one. I think education is awesome, and I would encourage everyone to get educated. But like I said, don't throw out the baby with the bathwater. Our property manager is responsible to verify that the contracted work is completed, and also take an inventory of damages by the contractor. This is a lawyer answer. It depends on your management agreement. So some management agreements say, especially if it's a significant project, the property manager will do project management for a specific significant project, but you have to pay him or her on a different scale, where the management company may put in additional personnel that you'll have to pay more for. Otherwise, if it's the normal day-to-day things, like the porter was cleaning out the trash dumpsters, the carpets of the high-rise were being cleaned, the trash chute was being cleaned, the elevator maintenance man came and certified to the town that it was okay to go. Yes, the manager should be checking all those normal day-to-day things. But if you're talking about project management, so re-roofing all the buildings in the entire community, certainly your property manager would not be doing that type of things unless there was some type of side agreement. Go ahead, Mike.
The next comment says, we have typically not interviewed assistant managers, but it makes sense to do so going forward in terms of succession planning. So thanks for the tip. The next question says, is there any required training for board members? It seems that board members should have some training to better understand association law. I know CAI has training, but is there any legal requirement for training board members? In short, the answer is no, there is no requirements. Other than being in good standing and owning the community. Other than that, there's no other requirements. That being said, I believe there's been legislation out there on and off for years requiring board members to have some sort of training. To the best of my knowledge, it hasn't gotten very far, but I've been doing this, I think, for 15 years, and I've been hearing about it for about 15 years or so, just like the manager training. Again, it hasn't gone anywhere. Fran, I don't know if you know if it's moved ahead at all ever.
So I think there are various bills right now out there floating around. And for those of you who are fortunate enough to have places in Florida, Florida does have a requirement, my understanding is, and there are states that have various requirements in between taking a class, or some have a certification requirement that says, I certify that I read all of the declaration pages, the certificate of incorporation pages, the bylaws and the rules and regulations. I don't know if anybody on the planet has ever done that, but apparently some states require that board members sign a certification that they actually read that 3-inch thick of pile of paper. As you know, that's what we get paid to do typically, which we actually do. But most board members, I know don't read the governing documents cover to cover. It's not a bad thing to do, as you know, and I've advocated this before. I don't have one in front of me right now, but I'm a great fan of the GAN book, written by Wendell Smith. I think I've held this up before. This is the GAN book for those of you, right? The GAN book. It's the condo GAN book, written by Wendell Smith and Dennis Estes and Chris Lee. So that's a great treatise. It's a great treatise on association law, association governance. And in addition to that, half of the book probably is appendices that contains the Condominium Act, the Planned Real Estate Development Full Disclosure Act, the Nonprofit Corporations Act, on and on and on. So for those of you who are really, really into punishing yourselves, you can read through this book, and it's a great resource. I think it's something that every association should have in their management office. Go ahead, Mike.
Somebody makes a comment that in Florida there is board member training requirements, which makes sense. Somebody writes, can an association make it a rule for potential board members to be trained? So I do not believe that would be permissible. And the reason I say that is the DCA last year came out in 2020, came out with their regulations. And in there, they were fairly specific that the only requirement to become a board member can be good standing. So it can't be good standing plus educational requirements, good standing plus you must live in New Jersey. We have some association governing documents that say things like that. And on their face, I don't believe that those would be enforceable.
Right. Mike, I missed one. There's a comment that says, hey, not all management agreements are alike, right? They're not all equal. So not only should you compare the price, if it's a flat fee price or it's a per door price, you need to look at the actual details of the pricing for the management agreement, because many management agreement proposals come in really low, appear real low, but everything under the management agreement is an upcharge. It's an upcharge for answering the phone. It's an upcharge for a postage stamp. It's an upcharge for a fax. It's an upcharge for an email. So even though the management company's proposal looks really cheap at first, at the end of the day, whether you're paying transfer charges, closing charges, collection fee charges, et cetera, you wind up paying far more perhaps than the flat fee management agreement of the other vendors. So you have to make sure you're comparing apples to apples, right? When you're looking at the pricing structure for management agreements. That's a good point. Thanks for the note. Go ahead, Mike.
Pretty much it. Right at the end here, somebody writes, can you please provide the title of the GAN book? So I have one here as well.
Yeah.
It's the New Jersey Condominium and Community Association Law. And it goes on to say, a practical guide to condominium and other common interest communities. So again, like Fran said, it's by Wendell Smith, Dennis Estes, and Christine Lee.
Right. And you can, I think if you just go to GAN's website, GANN, They are the publisher. So I think it's right. I think you buy it right off the GAN website. I don't have their web address handy, but I think if you just search GAN Publications, GANN, you can just order it right offline. And they have a hard copy version. I still like paper, right? I'm an old school dinosaur person, but you can also get the online version as well.
Eileen just put the link in case.
Oh, there you go. Thanks, Eileen. So the link is up there if you need it. So it's about 5 o'clock now. It's great to see everyone. Hopefully the rain will stop and spring will come. And it's good to see everybody. I hope everyone remains happy and healthy. Thanks so much for attending, and we'll see you next month.